Hi everyone, I'm attorney Aiden Durham with 180 Law Co. in Colorado, and welcome back to All Up in Your Business. On this episode of All Up in Your Business, we're going to talk about trademarks and things that can come up during the trademark application process. Specifically, I'm going to tell you guys about trademark disclaimers, what it means to disclaim a part of your trademark, and why and when you might need to do so. But first, don't forget to like, subscribe, and share, and check the description for links to additional information and resources, including my new Introduction to Trademarks guide that you can download for free. That link is in the description. And while you're there, make sure you check out my channel memberships, because I'm going to be posting a members only video as a follow-up to this one, where I'll walk you through the process of responding to a disclaimer requirement on your trademark application. All right, so the trademark application is a long and pretty involved process. It is by no means short or easy, and there are a lot of different things that can come up along the way. Typically, within about 3 months after you've submitted your trademark application, your application will be assigned to an examining attorney with the United States Patent and Trademark Office. This examining attorney is the person who's going to be evaluating your application to make sure all the information on your application is complete and that your trademark is available and eligible for registration. The examining attorney will issue an office action if there are any issues with your trademark application, if information needs to be clarified or corrected, or sometimes the examining attorney will just have questions or will need some additional information from you for your trademark. It's super common to receive some kind of an office action on your trademark application, but office actions can be issued for a huge variety of reasons. There are all kinds of different reasons that the examining attorney might give you an office action. One of the really common reasons that you might receive an office action on your trademark application is for a disclaimer. It will look something like this. Now, don't get this confused with other types of disclaimers that you might hear of in business or, in the legal world. This isn't the kind of disclaimer that you might use to avoid liability for something. This is a totally different kind of disclaimer. When it comes to trademarks, a disclaimer is a statement that you, the applicant or the trademark owner, do not claim the exclusive right to use a specific element or elements of the trademark. This usually happens when the trademark contains words which are merely descriptive, generic, or otherwise don't function as a trademark. The purpose of a disclaimer with trademarks is to permit the registration of a trademark that's registerable as a whole, but which contains elements that might not be registerable on their own. For example, descriptive terms used alone typically aren't going to be eligible for trademark registration. The fact that a trademark contains descriptive words is not enough to justify refusal to register it. Unless the trademark consists of only those descriptive words, registration can't be refused, assuming, of course, it's otherwise eligible for registration. When it comes to trademark registration, a disclaimer of a certain word or component of a trademark is really just saying that, as it relates to that exact trademark, no rights are being asserted in the disclaimed element alone, only in the trademark as a whole. In other words, simply put, with the disclaimer, all you're really saying is that you're not claiming any rights to use that exclusive term on its own, except for exactly how you're using it in your trademark. If you know for sure that a certain term or portion of your trademark is going to need to be disclaimed, you can just disclaim it right off the bat in the application when you submit it. But you don't have to do that in the application. The examining attorney will issue an office action if he or she determines that a disclaimer may be necessary, and they'll also give instructions and direction about how to make that disclaimer. So you don't need to be especially concerned about the disclaimer issue when you submit your trademark application. The office action will say something like, applicant must provide a disclaimer of the unregisterable part of the applied for mark, even though the mark as a whole appears to be registerable. It'll then go on to specify the element or elements of your trademark which need to be disclaimed and the reasons for it. Like I said, it's typically because that element or that word or term is generic or merely descriptive of an ingredient, quality, characteristic, function, feature, purpose, or use of your goods and services. It'll typically also include some additional evidence like a dictionary definition of the word or something to support their claim that the word is descriptive or otherwise needs to be disclaimed. The office action will then go on to say something like, applicant may respond to this issue by submitting a disclaimer in the following format, and then they'll tell you exactly what you need to disclaim and exactly how that needs to look. The exact phrase that they're looking for is, no claim is made to the exclusive right to use X apart from the mark as shown. Again, make sure you check out my channel membership so you can watch the exclusive members only video about how to actually respond to the disclaimer requirement in an office action. I'll give you a few examples of how disclaimers work. So my business has 2 registered trademarks and 1 pending application. I have a registered trademark for my business name, 180 Law Co., as well as for All Up in Your Business. My trademark for 180 Law Co. is used with my law office where I provide legal services. The term law is disclaimed because that describes the services that I offer. So as part of that trademark registration, I had to disclaim the word law in my trademark. Very similarly with All Up in Your Business, I use All Up in Your Business with this channel and with other services that have to do with business. So the word business in my trademark is descriptive of the goods or services that I use the trademark with, and so I had to disclaim the word business in that registration as well. And really, all that means is that I don't have the right to enforce against someone else using the word law or business in their trademark unless they're using it in a very similar way that makes it look like 180 Law Co. or All Up in Your Business. Really, I'm just saying that I don't have any specific rights to the word business or the word law, except for how I'm using them in my trademark registrations. But it doesn't impact my ability to enforce my trademark rights against somebody else who may be using a trademark that's similar to mine as a whole. Now, these rules for disclaimers and trademarks don't apply exactly the same across the board. There are a lot of situations where we might not have to disclaim a descriptive term or a term that might otherwise need to be disclaimed. And sometimes it's appropriate to respond to the office action with reasons why the disclaimer shouldn't be required. But in most situations, if the examining attorney is asking for a disclaimer, it's usually appropriate to make that disclaimer requirement. And ultimately, in most situations, it doesn't really have a huge impact on your trademark registration or the overall strength of your trademark rights. So to summarize, a disclaimer on your trademark registration is simply an acknowledgement that you don't have exclusive rights to a certain element of your trademark. In most situations, a disclaimer isn't going to have any significant impact on your trademark one way or the other, but there are certainly situations where it might be beneficial or appropriate to try to avoid that disclaimer requirement. Even though responding to this disclaimer requirements in office actions are relatively easy and straightforward in most cases, it's still always a good idea to consult with a lawyer before you make a disclaimer on your trademark. That's all for this episode, folks. Drop a comment below, let me know what you think. And don't forget to check the description for additional links and information and resources, including a link to download my Introduction to Trademarks guide. And check out my channel memberships if you want access to that exclusive members-only content. Thank you all so much for watching. I'm Aiden Durham, and I'll see you next time.